My name is Amy Vanderplug. I'm the Director of Sales for Porter Hills Village and Cook Valley Estates. And we have been doing a series of these virtual webinars now for over a year. It's been the best way to reach our audience. And so we're very glad to have those of you who are interested in this topic join us today. We've got a couple of good speakers. So we really listen when we're talking with families about, what things they maybe have questions about or need more education about. And today's topic is one of those that we hope meets that need. So before I introduce our speakers, if we can go to the next slide, this is just a little bit about Zoom. So for those of you who maybe are on Zoom with us today for the first time, just let me explain a couple of things. You as an audience are, you're muted and also your video is turned off, but what you can do is type in the Q&A button, which is at the bottom of your screen. That's where you can type in your questions for our speakers, any one of us. We kind of like to save the questions until the end of the presentation, but you can type them in throughout the presentation because we will see those and get your questions answered after our speakers go. All right, so let's go to the next slide. And I would like to introduce our speakers. So Nick Reister is an estate planning and business lawyer. So he's gonna bring the side of the equation, talking about different things that come up when people are looking at making a move to assisted living. So he's going to cover a variety of topics from powers of attorney, durable power of attorney, things like that. Nick has, as you can see from his bio here, he's got a lot of experience in this area, and he is the chair of the Trust and Estates Department for Smith Howey. If we go to the next slide, our second speaker is Jay Weisentainer, and he is a partner and investment advisor at NPF Investment Advisors. And Jay is also no stranger to Porter Hills, as he is the current chair of our Porter Hills Foundation board. And so Jay is going to speak on kind of the other side of the coin, talking about the financial aspects to consider when you are looking at Porter Hills at whatever level. So whether it's for yourself or an aging loved one. So between the two, I think you're going to find that they're going to cover a wide range, again, of things that we felt, we hear often from families that they have questions about. So just a reminder, if you have a question, go down to the bottom of your screen, click on the Q&A and type it in, and we will make sure that we get to all of your questions as we go through. So I'm going to kind of bow out here, but I'm right there if you need me, Nick or Jay. But I think that Nick is up first, and so we can go to the next slide. Welcome, Nick.
Well, thank you. It's a pleasure sharing this time with everybody, and I'm glad you have some interest in Porter Hills. I had the privilege of serving with Jay on the Porter Hills Foundation, so it's a distinct honor to be here talking with folks about what they might need to consider legally as they're exploring some assisted living arrangements. So we've got a number of slides here that I want to go through to kind of highlight some of the key things to keep in mind as you're considering and planning for that assisted living and possible transition into more elaborate care during somebody's kind of sunset in life. And so the first one here deals with powers of attorney, and we get a lot of questions about powers of attorney. There are a lot of misconceptions about how they work, when they operate, the powers that each of those provide. And so I wanted to kind of highlight two big important distinctions between possible powers of attorney. In the law, the term durable refers to the power of attorney being active and enforceable while the principal, so it's important to understand that with a power of attorney, there are really two parties in play here. There's the principal, that's the person who has the, me. I want to choose somebody to help me and be my power of attorney. I'm the principal. I'm the person that the power of attorney or the attorney in fact or agent is helping. As with a non-durable power of attorney, that power of attorney is only good and only effective while I have the mental capacity, presumably, to oversee the acts of the agent or attorney in fact. The durable power of attorney means that not only is it good while I'm able to oversee the agent, but also after I've lost capacity. So whether that's dementia or being in a coma or anything else, and it's only good during my lifetime. Both of these durable and non-durable powers of attorney end at death. So they're not really helpful after the fact. They're not a replacement for a will. They're not a replacement for a trust. It's merely a document that helps, that gives the agent or the attorney in fact the legal power to act on the principal's behalf. Without this, the public is not supposed to rely on one person's acts on behalf of another without something like this durable power of attorney. And so if you don't have a durable power of attorney and a helper is needed, then you have to seek the involvement of the probate court to appoint somebody as guardian or conservator on behalf of the age. On behalf of the principal. And that is what that order from the court, that appointment from the court, is what gives that person legal authority to act on the other person's behalf. This power of attorney deals with, I like to describe it as basically everything that a person has to deal with in their life except healthcare matters. So contractual things, dealing with assets, buying and selling real estate, depositing or withdrawing assets from bank accounts, dealing with things like taxes or government benefits are common uses of these powers of attorney. In this phase of life where we're talking about assisted living, gifting powers are commonly included in those powers of attorney. And what that does is gives the attorney in fact the power to give assets that the principal has, give the principal's assets to other people. And that's a time when oftentimes the folks that are going into assisted living are starting to want to see their kids benefit from what they've saved up over the years. And so it's a very common thing to do, but those gifting powers also could serve to help develop a plan for the attorney in fact's needs, long-term care needs. And so when you're considering durable powers of attorney, consider including gifting powers, because that's going to be a helpful tool to make sure that a plan is, whatever plan might be needed for you as you're entering assisted living, that it is as well tuned for your needs as possible. Jay, anything to add on that topic, or should we move to the next slide?
No, I think you covered that pretty extensively. Thank you.
Good.
All right, next slide, please.
So I mentioned that the previous power of attorney that we were just talking about dealt with everything except healthcare. And so the other side of that coin is the healthcare power of attorney. And in Michigan, we refer to the person who is appointed to make a person's medical decisions for them if they're not able to make them for themselves, as a patient advocate. The document that appoints that person is commonly known as a durable power of attorney for healthcare. It appoints, again, like I mentioned, a person who will make care and medical decisions for a person when they're not able to make them for themselves. And it avoids the need for needing to ask a probate court for appointment as that person's guardian. Again, like dealing with resources or assets, I cannot make decisions for Jay without Jay making me his advocate or his agent. And so if we decide that Jay needs help and I think I'm the person to be able to help him without the durable power of attorney for healthcare, I have to go to probate court and ask the court to appoint me. That's not all that desirable for a number of reasons. You're in a public forum, so everything that is submitted to the court is open and available for public inspection. It's often at that point been quite some time. It takes a little while to get in front of a judge unless it's a dire emergency. And then there are the costs that go along with applying to the court, and then you've got to report regularly to the court at least once a year. And so the patient advocate is a real desirable way to go. It should avoid the need for going to court. And the patient advocate's available to make immediate treatment decisions if necessary. It's important to note that when you appoint your patient advocate, they can't veto your own decisions. It's only when you can't knowingly make your own decisions on your own behalf. And that decision, when it's determined that you can't make your own decisions, is done by a physician, and the physician has to examine you and have to put in writing that you no longer have the capabilities of handling your own medical decisions. And that's reviewed at least annually. So you can always regain your ability to make your own decisions. But when you can't make your own decisions, that's when your patient advocate is able to step up and make decisions in your best interest. It's important to note that in today's day and age, when we're concerned about privacy and identity theft, things like that, that there are laws in place to protect you. But those same laws can interfere with a patient advocate's ability to make informed decisions. The patient advocate needs to have access to your patient records, and the care providers have to be protected from disclosing your information to your patient advocate. So any patient advocate that you have should have what we call a HIPAA authorization. HIPAA is the abbreviation, the kind of common name for the federal law that deals with a patient's privacy as it relates to their health records. So that authorization says that you waive and you allow a care provider to be able to release your private information to your patient advocate so that patient advocate can make medical decisions. In these patient advocate documents, I like to have things in there that make it more personal. Things like your religious beliefs. If you have strong feelings that impact how your care should be provided, or perhaps tests or things that should not be provided, those should be included in that document. If you have preferences for where you reside or where you don't want to reside, those should be in there. Things like times when life support should be withdrawn are also a real popular thing and an important thing to put in there, because you're giving guidance to your patient advocate so that at the time that that question is asked, whether life support should be withdrawn, your patient advocate has that assurance that they're making the right decision that you would want made. Similarly, organ donation or burial and cremation instructions are commonly in those patient advocate documents. And again, that's that's to serve as some reassurance to your patient advocate that they're making the decisions how you would want them to be made. Jay, anything on that one before we change slides?
No, just emphasizing that it's so important, as you mentioned, to get these in place when you can do it, not waiting.
That's right.
It's too late.
Yeah, the key to this is that you can only make these documents. You can only have these documents prepared when you have the cognitive ability to understand what you're doing. And so it's not a pleasant topic. Nobody, I think, really enjoys thinking about end of life decisions, but it's critically important. And I like to remind my clients that it's not really about you; it's more really about your family. And by setting up these documents, you're really kind of investing in their emotional and I guess their emotional ability to get through this difficult part of life where they're going to be probably saying goodbye to you eventually and probably seeing you decline and not be the same person that you have been for their whole lives. And so it's really important. It's a helpful tool and an investment in their well-being. All right, I think we can move to a next slide, please. I often get questions about do not resuscitate orders or DNRs. They're not the same as a patient advocate, the one we just talked about. A do not resuscitate order by law is a statement by you that says you don't want any intervention if your bodily functions are ending. So if your heart stops, you don't want CPR. And somebody who intervenes in that could be held legally liable for intervening. And so I understand that there are times when DNRs are appropriate. There are certainly people who are frail, and if CPR was to be performed, bones would be broken. It would be a bad thing, and it might be better to just not intervene. But too often I get questions from people who ask for DNRs, not understanding the implications of DNRs. And I'll ask them, let's say you have a heart attack. Do you not want CPR? And they say, no. I just don't want to be on life support. Well, it's important to understand the distinctions. And so there are limited uses for these, in my opinion. They're typically offered by physicians in hospitals, although attorneys will help prepare them as well. And the law has very explicit instructions and requirements for how these are prepared. Notably, each of these have to be executed by you, the patient, by your attending physician, and 2 witnesses. So it's you have 4 people signing. It's a pretty elaborate execution process for it to be done right. All right, I think we can go to the next slide unless Jay has any other questions. All right, guardianship and conservatorship. Now, I touched on these briefly in reference to the durable powers of attorney and the patient advocates. Guardians deal with a person's well-being. Conservatorship deals with a person's assets. Both people, guardians and conservators, are appointed by the probate court. So you have to apply to the probate court and ask a probate court judge. You have to prove to the probate court judge that the person needing the guardianship and conservatorship actually needs it. That the person is not able to handle their own affairs for one reason or another. And then you have to ask the court to appoint somebody. And as I mentioned earlier, it's a time-consuming process. It's not something that happens overnight. And again, it is public, and you're kind of leaving your fate up to the judge to make a decision in your best interest. The way that we kind of control that situation and try to improve on that is by putting together the durable powers of attorney and the durable powers of attorney for healthcare, or the patient advocate designation. When I mentioned leaving decisions up to the judge, one of the issues that is left up to the judge is determining who should be appointed. And without having anything in writing, Michigan statute governs and has a priority for who should be appointed. That tends to be driven by familial relationships, so spouses, children, etc. And that order may not be appropriate for your family circumstances. So it's important to not rely on kind of the default order that's in the law, but choose who you want acting on your behalf. Just relying on that default is not a great idea when there's any kind of family distrust or disagreements, because it could put your family members in positions where they're going to be arguing against each other or challenging each other with whatever decisions or appointments are made. So again, you're making an investment in your family when you have documents put together for yourself. And then it's important to understand, I think I touched on it briefly too, that whenever you are appointed by a court, that court is overseeing, not daily, but legally overseeing your acts as a guardian and as a conservator. And one of the ways that the court does that is requiring you to report to the court. And that needs to be done annually. It's not what I would consider a simple process. It takes some preparation. And the court will often review that and might call you in for a hearing to discuss it. And that's not necessary when you have powers of attorney or durable powers of attorney for healthcare. So again, preparation of those documents saves time and makes life easier, both on you and on your family. Okay, next slide, please. Now, this is, I think, probably the top question that we get when people are thinking about assisted living, and that's this concern that people can't afford it, right? Lots of common conceptions that that assisted living is something that is just going to burn through all of your assets. Excuse me. And that it's going to leave you penniless and broke. But in this conversation, there are a lot of different variables, and it's important to understand the differences in those levels, whether it's staying in your own home and having care come in from time to time. Sometimes it's a couple times a week. Sometimes it might be daily. Other times it might be around the clock, but that's one level of care. And then there's assisted living, where you live more or less in an apartment, and there are folks in the building who are around to help you from time to time as you need. And then there's skilled nursing, which is, I think everybody's familiar with what a nursing home is like, but skilled nursing is that top tier of care need. As you might imagine, the more you move up that spectrum from in-home care to skilled nursing, the cost increases with that, because more staff is needed, more specialty is needed, and more resources are required in order to provide that level of care. There's a lot of questions about whether or not you can qualify for Medicaid to provide help with those living arrangements, with your needs. It's important to understand that this public assistance is targeted to the higher level of need, the skilled care. And and it's meant for people with very limited financial resources. I don't have, there are times when we get calls or hear from people who have done well for themselves during their lives. They've saved up, and they have a healthy amount of resources in the bank. But they want to save that money for their kids. They want their kids to have those resources. And so they want to qualify for Medicaid. And that's a real challenging notion, because the amount or the level of care that that is provided by Medicaid is less, it's lower than what a private pay person is able to pay for. And when you plan in advance, so a lot of times I'll get these questions from folks who are in their 60s, maybe 70s, and they start to worry that, quote, the nursing home is going to take everything they own. And they want to do some planning for that. Usually, the people that are asking me this are quite healthy. They're trying to be wise and be good stewards of their resources, and they're thinking about their kids typically. I think a lot of times folks asking these questions feel like they're being very noble in asking them, and I can appreciate that. Things to keep in mind, though, when considering that are that advanced planning like that is really trying to hit a moving target. That law or the body of law that deals with Medicaid assistance for long-term care, again, is meant for people with very limited financial resources. And so the government is constantly trying to prevent people who have more than limited financial resources from qualifying, because the government can only afford so much care. And so that law is constantly changing, and the rules and considerations for qualifying for those for that assistance is constantly changing. And so, if you're trying to plan for years down the road, maybe 5-10 more years, it's difficult to know what the law is going to prohibit and what the law is going to allow. And usually that planning is quite expensive. And so I don't typically recommend any kind of real advanced planning like that until you know that you're going to need the care, because statistically speaking, the odds are probably that you're not going to need skilled nursing care. And if you do, you're probably not going to need that skilled nursing care for several years. You're probably going to decline, over a course of months, but rarely is it multiple years that a person is in that skilled nursing that public assistance is going to help with. So usually my preference and my recommendations are to be smart, to not forget about the ability to plan, but waiting until you know that need might be possible. And there's a lot of planning that can be done at the time that you know that you need the care, or your family member needs the care. And so that at that point is a prudent time to give your attorney a call and ask those questions and see what might be able to be done to be smart with your resources and make sure you get the care that you deserve and that you need. So I would really caution, it tends to be an area of the law that is somewhat predatory. And so big fees are often charged for planning. The reasoning being that if an attorney can promise you or represent to you that you're going to save hundreds of thousands of dollars in nursing home care, that they should get a large portion of that. or split those savings with you. I'd really caution you against that. I don't think that that's appropriate. And I'd encourage you to maybe get a second or third opinion before you move forward with any planning. Jay, anything else on that one?
No, but thank you, Nick, for navigating us through particularly this delicate matters. I myself went through this several years ago with an aunt who's a resident at Porter Hills now in the memory care unit, and it is overwhelming. But you did a very good job of clarifying it and distinguishing it and bringing up the risk. Maybe we can go on to the next slide then. And this is where I come in. I'm, as Amy had mentioned, chair of the Porter Hills Foundation, and through our affiliation with UMRC, we have a very strong foundation of $49 million. And the cornerstone of our foundation is benevolent care. And this is what we pride ourselves in doing, for supporting qualified residents who have outlived their financial resources and are unable to pay the full cost of care in these licensed areas of Porter Hills or UMRC. As Nick mentioned, the skilled nursing areas. So in situations like this, a lot of times someone will come into the assisted living, be qualified, and then in the continuum will go into either memory support or skilled nursing care. And what we're having these days is we're living a lot longer. Residents, I've wrote birthday cards to many residents who are selling their 100th birthday and even higher at our facilities. And by no fault of their own, they're outliving their assets. And that's what our foundation is there for, in the benevolent care for these qualified residents, to make sure that they can continue to receive the care in our facilities. And again, it's the support of people like Nick that were on our foundation board, and people who care about Porter Hills UMRC, who continually year after year contribute to the foundation to meet these needs. And it's, as I mentioned, it's a cornerstone of what our foundation wants to provide. And in addition to providing educational support for staff members, so we have lower turnover, and supporting them, particularly during this pandemic we had, when it was a challenge for our staff members, raising funds for emergency money for staff members so that they can come into work every day to care for our residents. But that's the reassurance that we have at Porter Hills, is benevolent fund that is there for any of our qualified residents who outlive their financial resources, to make sure you continue to get the skill care that you need at our facilities. Nick, did you have anything to add to the foundation's role in this? I may need to unmute. Sorry, Nick.
Sorry, I muted myself. I don't. I'm just thankful that for the supporters of the foundation who've over the years had the forethought to build something like this to help folks who may need assistance.
Thank you. Maybe we can, if Amy is still on the line, we might, I see we have some questions from the viewers.
We do. We've got some good questions. So let's start here. All right, so this is a little scenario that we have here. Could two sons be both on the patient advocate form and the power of attorney? And this person says that both she and her brother were equal for their mother as power of attorney and healthcare advocate, and it worked very well for them. But is that still something is that allowed, that you can share that with a sibling?
Yes. Yes, it's possible, I guess, is my answer to that. And as you might imagine, each family, each individual has different dynamics and different considerations. When there's harmony in the family, like it sounds like uh, like we had in that example, it can work really well. And it's nice to be able to split the burden among several people. Usually, I wouldn't say probably more than two people, but occasionally we'll have more. Um, some of the risks, though, are perhaps disagreements that can't be resolved, or uh, there are kind of nightmare scenarios where documents aren't clearly drafted, and perhaps somebody prints something off from the internet and appoints two people, but there's no tiebreaker provision, or it says that the parties must agree, and maybe they would agree, but one person's unavailable because they're traveling on the other side of the world and aren't reachable. I've actually had an instance like that where somebody was in rural India and couldn't be reached, and we had to figure out a way to kind of get the care providers comfortable with accepting decisions from the person who was here and not traveling in rural India. So is it possible? Absolutely, but it's something that you need to make sure that the documents are clearly drafted and crafted in a way that fits your family's dynamics.
So another question is, who actually needs these power of attorney and patient advocate forms?
Yep. So very good question.
Yeah.
Yeah. So I recommend that everybody have these. All the way down to, I've got a senior in high school, and when he turns 18 and heads off to college, he's going to have these documents, because when he becomes an adult, I can't make decisions for him, and I can't access his information unless he's given me that power. And so, it's everybody from 18-year-olds to 118-year-olds. And when you set them up, the patient advocate needs to be signed, and it also by you, and then it needs to be accepted by your patient advocate, whoever you're appointing. And then after that, you should make it part of your patient file, whether that's with your primary care physician. I believe that when people move into Porter Hills asks for a copy of it.
Yep, we do.
And that way, when the patient advocate services are needed, or involvement is needed, people aren't rummaging around looking for it, trying to find it, so that everybody knows how to proceed. Powers of attorney are a little bit different. I would say if you're still able to handle your own affairs, I'd urge you to maybe proceed with caution on sharing powers of attorney documents with your agents. Until their active involvement is needed. You might tell them where they can find them when their involvement is needed. But certainly when you need help with things like banking and bill pay and that kind of stuff, that's a time to give your agent a signed copy of your power of attorney.
Okay, so Nick, on your slide about the benevolent fund, we have a question. What is a qualified resident? Because you use that term in the second bullet point. So
yeah, I can answer that.
Sure.
Upon applying the Porter Hills, either an independent living or skilled care, there's some financial questions. There's an application process you go through, and at that time, you become qualified to be accepted and join become a resident. And then while you're a resident, you fill out annual questionnaires regarding your financial situation. So that's what it means by a qualified resident. You're going through the applying process of being accepted as a resident, either in the independent living, assisted living, or skilled care facilities at UMRC Porter Hills. I hope that answers the question.
Yep, and I can just add to that, because as the sales director, that is part of the application process for anyone looking to move into any of our communities. As Jay said, there is an application, and part of that is a financial disclosure form, if you will. It's not super detailed. You're basically listing your income and assets and any liabilities against that. We have a computer software program. It's an actuarial program that runs your financial information against the cost of living at Porter Hills at whatever level you are looking to move into, whether it's independent living or one of the high levels of care. And what that software program or that actuarial program does is tells us as an organization what, if you do qualify, and what it's looking at is how long are your assets going to last. So with this benevolent fund slide up there, which is a great one to have up while we're answering this question, it's as long as, if you've been accepted as a qualified resident, then you have access to this benevolent fund. And so, there's things about the actuarial program that are a little bit crystal ball-ish, if you will, because it does take into effect your age, but the software program is using actuarial tables actually. And so it's predicting how long a person might live, and then also how long will their assets last. And so that's really, in a nutshell, between what Jay and I said, that's what it means to be a qualified resident.
Thank you, Amy.
So Nick, there's a question here that goes back to the conversation about conservator and guardian. So I think you touched on this, but the question asks, can you tell us again, what is the difference between a conservator and a guardian?
Yeah, a conservator is appointed to be responsible for handling a person's assets when that person can't handle their assets anymore. And a guardian is responsible for kind of the care and well-being, the care and feeding of a person when they can't do that themselves. When a guardian is appointed, a court is determining that that person has some inability to handle their own affairs, and the guardian is appointed to handle that portion of that person's affairs that they're no longer able to deal with.
So would that typically be the same person, or would that usually be two different people?
I would say the majority of the time it's the same person.
Okay.
There are unique circumstances where those might be different people, but oftentimes you're applying as guardian and conservator.
And from my perspective at Porter Hills, I would like to just reiterate, I think what both you, Nick and Jay said, don't wait to get these things set up, until there's a time when maybe you are, or your loved one is not able to make those decisions on their own. We do occasionally see that at Porter Hills, where we have, sometimes it happens with someone who does not have children of their own. And then they, and oftentimes it has to do with cognition, and things, are changing with regard to their memory. And these things have not been set up, and there's no immediate family members. And then it's very difficult to move forward in a timely fashion when these things have not been set up ahead of time.
Yeah, procrastinating is not a strategy. Unfortunately, too often, and I've had 2 meetings already this week with people, with family members who we've had to have some really hard conversations because their loved one didn't plan properly. They didn't expect to get sick, or they didn't expect to die. And unfortunately, that person had plenty of options had they called us and not procrastinated. but now the family members are left with many fewer options. And unfortunately, sometimes that's a conversation about one bad result compared to another bad result. And that's not fun.
Yeah.
I think it's important for people to again be reminded that when you invest in this process, you're investing in your family members. And I would say the majority of folks care probably more about their family members than they do themselves, particularly here in West Michigan. And so, make that investment. And it's also important, I think, to understand that when you contact an attorney to talk about these things, you don't have to have all the answers. We help you work through the different considerations and hopefully help you come up with an answer that you feel comfortable with. Too often I get people who call and say, I want to do this, but I haven't decided what I want to do. But we haven't even had a conversation, and we need to have those conversations. There's not much that's new under the sun for us. As unique as each person and each family is, there are a lot of familiar patterns and lots of solutions that we can offer you to help you figure out something that you've had difficulty figuring out.
Thank you. Okay, there's another question here. Can you do a quick summary of the difference between the durable and the non-durable power of attorney? And this does get a little bit confusing.
Yeah, and I'll do it very simply. Durable means that it's good while you have mental capacity, and it's also still valid when you don't have mental capacity. So if I put a durable power of attorney together now and appoint my wife can act right now. She'll also be able to act if I'm in a coma or if I have dementia. That power of attorney will remain valid. A non-durable power of attorney is only valid while I have the ability, while I have the capacity to basically to oversee the agent's actions. So again, durable power of attorney is the one that you want. Non-durable power of attorney would be something like naming somebody to sign on your behalf at a real estate closing. They're not all that useful these days. What you really want is the durable power of attorney.
And typically when with a husband and wife, do you recommend that they are each other's DPOA?
That's usually how people set that up. I think too often people just presume because we're husband and wife, we're in that position already. But there are plenty of times when that's not the case. And so a lot of times spouses will be the first choice, and then somebody else like a child or a sibling or a parent is a secondary appointment.
Okay, so if we can go to the next slide. So I don't see more questions here, but if they come up here in the next minute or so, type them in. We're happy to answer them. But just as a way to kind of bring this all together, Porter Hills Village and Cook Valley Estates are two of the main campuses on the west side of the state here. Jay had alluded to the fact that we are affiliated with United Methodist Retirement Communities, which are all on the east side of the state. But at Porter Hills Village, that is where the full continuum is. So we've referenced this a couple of times today. We have independent living. We have what we refer to as enhanced independent living. So with some more services included for folks. We have assisted living, memory care, and our health and rehab center, which is skilled nursing and rehabilitation. And so, as I said right at the beginning of this webinar today, we felt like the things that Nick and Jay were talking about today are things that we know families that we are working with have questions about. And what's really great is when families are asking these questions before their loved one has come to Porter Hills. But we do see things, as I said, after people have moved here and they didn't have these in place. And then it causes the family or the extended family to have to scramble when there are some health changes. So actually, it's part of our application process that we are asking you, do you have a durable power of attorney? Do you have a patient advocate? Is there a DNR? Those are questions that we ask. And sometimes if families or the prospective resident has not thought about these things, those questions might be a little bit off-putting. But I hope that after hearing from Jay and from Nick, that you can see that these are things that are important and they're important to think about in advance. So I don't see, well, I do see one more question. Oh, well, this is great. This says, awesome presentation. I help with skilled nursing facilities and Medicare. I would love to work with you with the whole financial picture. So this is great. Thank you. I echo that. This was great, Nick and Jay. We thank you so much. We know you guys are busy and we appreciate you taking the time. We also appreciate both of you and the work that you do with our foundation on that board. That's, as Jay, you said, that's really the cornerstone of Porter Hills and the promise that we give to our residents. So thank you all for participating. Thanks, Jay and Nick, for being with me today.
Thanks for having us.
And thanks for facilitating this for us, Amy, to share this knowledge with our viewers.
You bet. So for our audience, if you have questions about Porter Hills Village, we encourage you to reach out to Joy Zelenak. Her information is on the screen in front of you. Thank you, everybody, so much.